So thank you very much, Mike.
Thank you very much, ladies and gentlemen, and gentlemen from the CCRC. Good afternoon. Running a little bit behind time, and I will try and bring it back in together. So, my name is Mike Naughton. Same spelling, more hair, and I'm a private investigator. My background is predominantly military. A very short time with North Wales Police. I say I was a special constable, and people think, oh God, Saturdays and Sundays, or SAS, Saturdays and Sundays. But I served as quite a mature special constable, carried my own caseload, took out a car, and quite often on a Friday and Saturday night was working on my own, breaking up fights in Mold, around North Wales. And I was approached by another private investigator who specialised in the cheating husband, cheating wife, surveillance, things like that. He said, I said, I can get you a bit of work if you want it. And I thought, yeah, because it took me back to my military days of sitting in a tree covered in squirrel poo. That wasn't when I was working, by the way. So I took him on. I had to resign as a special constable, still carrying a day job. And I was hooked almost from day one. And for the first couple of years, literally just the first, from 2008 to 2010, 2011, I did the cheating husband, cheating wives. We had his and hers tracking devices. I was sitting in a tree covered in squirrel poo again. And that was okay, but I was then approached to be the defence investigator because what I should have mentioned was criminal law became my bedside reading. Much to the annoyance of my ex-wife, I would sit there with the police operational handbook, and I was fascinated. And I think with any subject, if it interests you, it goes in. And this was all going in. So then, back to 2010, and I was approached by the defence team for robbing Garbutt. And robbing Garbutt's case was the very, very first criminal defence case that I investigated. Unfortunately, in my opinion, and in Jane's opinion, and Michael's opinion, robbing Harbour was subsequently found guilty and sentenced to 20 years in prison. So anyway, so what do I do now? I don't do the cheating husband and wives, I don't do the surveillance, I don't do anything like that. I predominantly sit, unless I'm coming out to meet up with clients, and there are some of my clients here today, people that know me, and some people that know me from Twitter that we've never actually met. So what I do now, I'm usually approached once the case has either been found guilty, so we've had a case, we've had a guilty verdict, or we've had a guilty verdict and we've gone to appeal, and the two appeals have failed, and then it's being put through to the CCRC. My dream job is when people come to me before they've even been charged. You come to me before we've been charged, and we can go and look at the evidence. Because believe me, the police will fail to disclose evidence. Yeah? So they'll fail to disclose evidence. And sometimes what they will do is they will take away your livelihood. They'll take away everything you've worked for the last 10 years, in excess of 10 years. And so I'm speaking to one of my clients. In excess of 10 years, they'll take that away from you. And then they'll come back and say, yeah, there's not enough evidence to pursue a conviction. There wasn't enough evidence to pursue a conviction in my client's case because the evidence was a genuine false allegation. Now, we're a number of years on. I'm now working with the clients to look to see how we can get the police to account for their actions. So we're taking it back to the police, and this is what people should be doing. If the police have failed them, if the police have caused them to lose such vast amounts of their income, to lose their home, then somebody should be accountable for that. An NFAR doesn't give you your day in court. A little bit like Joel said, he would have loved to have had his day in court, because had he had his day in court, he could have proved his innocence. But it's easier for the police not to give you that day, not to give you that day in court. You can go down the route of a claim against the Human Rights Act, Article 6, the Human Rights Act. However, you've only got a year. And a lot of people don't realise that. They think, yeah, we'll go down the human rights side. You've only got a year. So anyway, so where do I come in? So people contact me. Rarely am I contacted by a solicitor. Very, very rarely. And that's one of two reasons. One, because they don't know I exist. And secondly, and forgive me if there's any lawyers in here today, any solicitors? Oh, that's okay. So, and secondly, because it's their money. Why should we give you our money that the client's paying when we can do that job? The problem is, the solicitors aren't doing that job. You know, you'll sometimes take 80, 120,000, 150,000 from you and come back and say, no, you've got no grounds of appeal there. When in reality, they've not really looked. So what I do is, to give an example, I went to see a young man in Wymont Prison in Preston on Thursday morning, apologies, Thursday morning. And he said to me, right, he said, these are my grounds for appeal. And I looked at them and we went through, and he must have had about 10 grounds for appeal. And I had to put a score through every single one of them. I said, none of these are grounds for appeal. None of this is new, fresh evidence. It's got to be new, fresh evidence that wasn't in the hands of your counsel as your defence. It's got to be evidence that nobody has seen before. Now he said, yeah, but my defence just chose not to use it. And I said, well, that's what they class as a tactical decision. The law needs to change because at the moment there's no accountability for inept, ineffectual defence solicitors. And this is where a lot of people here today that have maybe gone through the legal process and could have actually had a really good case if the law was changed so that if you can demonstrate, they do say ineffectual defence is a ground for an appeal against conviction. I challenge you to find a law firm that will take on another law firm and accuse them of screwing up. Yeah. They all drink, they all eat in the same wine bars. And this is the problem. I honestly believe there is an unspoken rule between lawyers that ineffectual defence, we'll try and see if we can bat it off, we'll bat it off. Every single case that I have ever dealt with, since I've been doing this, and I've been doing this for a long time now, giving up all the other lines of work, every single case I've ever dealt with has an element of ineffectual defence, bar none, okay? At the same time, every single case I've also dealt with has an element of non-disclosure. You know, a non-disclosure could be anything. Non-disclosure could be a witness statement. Non-disclosure could be I'll give you an example. It's always best to give an example. So, I've got a client who served 7.5 years at Wymont Prison, and that was a sexual offences case. And in that case, the police took, if you read the statement of the complainant and studied the ABE interview, the Achieving Best Evidence statement of the complainant, it would read as if there would have been a vast amount of DNA on the bedding. Okay, they were a young, newlywed couple, and it is alleged that over 3 days, he multiply, is that a true word? I just made that one up. Multiply raped her, okay? And the way it's described. Now, the police took the bedding away. The police brought the bedding back and gave it to the family, still sealed, in an evidence bag. The evidence bag was still unsealed. Happy days. There was no evidence, so they'd had it tested. They hadn't declared it in the unused evidence because there was nothing on there. There was no DNA on there. I took the evidence bag. I gave it to a firm that were down in Cambridgeshire who took the bedding, sent it back. There's nothing on there. So somebody somewhere within the police took the bedding, they had it tested. Oh, it doesn't match up with what the complainants have said here. Let's give it them back. So when I take, sorry, I'm jumping around a little bit here. So when I take a case on, the first thing I want is the case file, the complete full case file. Every one of my clients signs an authority to act. That means I can contact the CPS, I can contact the police, and more importantly, I can contact the original defence solicitors. And I can request it. I have what they call a CJSM email address, which will allow a very large file to be transmitted by email. I get a complete fake case file. From then, I don't want any more contact with the defence. It's usually the defence that have failed the client. So I've got everything that's a download from what they call the CCDCS, which is the Crown Court Documentation System. Yeah, CCDS. So everything's on there. All the evidence, all the witness statements, all the unused evidence, everything is on there. So I can then start trawling my way through it. The other thing I want is the trial transcripts. Because another grounds for appeal is evidence that the trial judge misled the jury. Okay, so that is always a really, really important piece. And I say it costs, sadly, something that, in my opinion, should be free to anybody who wants to put in an appeal. They can sometimes pay thousands, 5, 6, 7,000. If you're looking at a complex case that ran over a number of weeks, it is thousands of pounds to get the trial transcript. But once we've got that, we can then study it. We can look to see what witnesses said at trial, compared to what they said on their original Section 9 MG11 witness statements, and more importantly, on their AB interview. For me, the AB interview is more important than what they said on their original statement. So then I start to go through this information. Quite often, as in a case, and I was hoping the gentleman was going to be here today, and he's not here. In this one particular case, his son was found guilty under Section 1 of the Sexual Offences Act. The police entered the property. They said, right, the usual, okay, what were you wearing last night? Can I take that? And they put it in an evidence bag, what were you doing? But they then started to ask him a number of questions. How do you know the complainant? What happened last night? How much did she have to drink? So you took her home. They're actually conducting an interview before he'd even been taken into technically into custody. He'd been handcuffed, he'd been given his rights, which is great for us because suddenly he's then being interviewed, and it's a breach of PACE, the Police and Criminal Evidence Act. And I noticed this because I have a qualification in linguistics. It's not worth a dot when it comes to the criminal courts. You know, I can't give a statement as an expert in linguistics, linguist. But what it does give me is an area to recognise where somebody's lying. In this particular case, I'll give us an example. It was presented as if he'd made what they call, some of you will understand what I mean, significant statements upon arrest. And it had been presented as if he'd said, I said this, he said that, and that's what he said on arrest. Where that police officer fell apart was, well, all four of them did. None of them, they all had switched off their body cams before the actual arrest. So reading the statements, I'm reading this, I'm thinking, that doesn't look right. So I went to see the client who was down at HMP 1, down in Nottingham. And I said, right, before we say anything, I want you to talk about the actual arrest. What was said to you? And he started saying, well, they started asking me lots of questions. And what did you say? Well, I said this. So the way the police officer had drafted her own Section 9 MG11 statement was that he'd voluntarily provided this information. But you can tell just by reading it, they weren't significant statements. They were answers to questions. So that gave us our first one on this. What she then did, she didn't draft up a Section 9 statement for over 79 days. I think it was 79 days after the arrest. She didn't do it's now, back in the day, we all had these. It's not all electronic. She didn't put anything into her pocket notebook or electronic pocket notebook for 7 days when she came back on shift. So, where's your memory? And this was all missed. The point I'm trying to make is, from the solicitor's point of view, this was missed by the police. Okay? Other cases, we've got blatant breaches where the complainant, I'll give you an example. A case where the police officers, they took the mobile phone of both my client and the complainant. Okay? They do what they do like a full extraction, and I'll go back to that in a moment. Am I all right for time, Mike? I'm all right. Oh, okay. So, they did the full extraction. I'm reading the extraction, and it was suspected in this case that she'd been seeing somebody else. She'd been on another couple of guys on the go. She was making up these false allegations, and this is after trial. This is a case that was going to the CCRC. The family had been charged the best part of £70,000 cash, and I stress that, cash, by a barrister to look through the case file. And I'm looking this and thinking, this isn't her phone. It was her mother's phone. She was even listed as a contact on that phone. And the messages that I'm reading, none of them referred to her. So she handed in her mobile phone. Did the police check it? No. Although at trial, it was heard her saying to another police officer, "Oh my God, how many phones has this girl got?" And that was heard, and that was, but by that time it was too late. I will pop back to that case very, very shortly. So my job is to go through your evidence. My job is to go through doing the job that defence should have done. Almost like, and this is what I say to people now, almost like having your own detective, almost like doing the job that the police should do. Because sadly, and on the back of numerous accounts you'll hear here today, the police do not do a full and thorough job. And there are far, far too many people being convicted on fabricated evidence. I've got evidence of fabricated evidence. Every now and again I'll put something on Twitter. Lancashire Police, we asked you to obtain a witness statement from Dubai. Dubai Police will only give this witness statement to the CCRC. That's what they've said. But I went to Lancashire Police and said, this witness statement needs to be obtained. Do you know where my email ended up? It ended up on the desk of an inspector who worked in professional standards department. Where's that going? It's just unbelievable. Absolutely unbelievable. So, and the other issue as well, going back to mobile phones, okay? So, what the police do is they take a mobile phone and they do a full extraction, okay? What they then do, they take that extraction and they feed it into a piece of software, and then they can cherry pick exactly what they want from that extraction. And they present that extraction to defence. They say, there you go, there's your extraction. There's no evidence on there. There was nothing. And lawyers trust the police to do this. And this, again, is part of the big problem, is that lawyers are far, far too trusting of the police. They just assume that the police have investigated without a full, fair and impartial investigation. We're talking of breaches of CPIA, we're talking of breaches of RIPA, we're talking breaches of the National College of Policing. Breaches of PACE is my favourite one, because they happen all the time. So they present this, going back to my phone analysis, they present this report. So a defence goes through and says, I've got nothing to go on there. What the defence should be saying is, look, don't give me a little report. Give me the full extraction and we'll get a report ourselves. But they won't, because it costs them money. And if you're on the legal aid, you're screwed. Seriously. I once had a very, very prominent solicitor say to me, a guy that I actually do a lot of work with, a very, 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 very prominent solicitor. He once said to me, Mike, he says, the reason I don't do legal aid work is because it ends up in a pile on the corner of my office. And every now and again, I'll go over, pick it up, have a look through and do a bit more, and it goes back. For what they get paid, that's another story. The legal aid system absolutely stinks at the moment. Moving on further with the mobile phones, it's now, if you are a female and you make an allegation of sexual offences, and I should have mentioned at the start, the vast majority of the cases that come to me are sexual offences, which I think in itself is quite telling. They come to me and they'll say, did they take the mobile phone? They took mine, but they didn't take hers. Because the female no longer has to hand over her mobile phone. And that's thanks very much to the, I think it was the Victims Commissioner, who fought hard. Pardon? That's the one. She fought tooth and nail so that women did not have to hand over their mobile phones, and because it was a gross breach of their privacy. No, it's not. It's a message. Let's go back to Liam Allen back in December 2017. Liam Allen, he was lucky that his barrister went through the mobile phone image of the complainant. And she spent the night going through it, and I think something like text number 2425 turned out to be a text message from the complainant to her friend saying words similar to, I can't be quoted on the actual wording, well, he's not really done anything I didn't want him to. Okay? And then we move on to the people like Ched Evans' case, the footballer, who basically lost his career because officers of North Wales Police decided to build a case. They took the girl back who'd made the complaint and said, you knew that is, don't you? She'd only said that she'd lost a bloody purse. You knew that is, don't you? That's Ched Evans, football player. And that's his mate who came in with you. And suddenly, pound signs are ringing. Luckily, Ched Evans was one of the lucky ones. So that is what I do. I prefer a full report either as an investigator or as an expert witness, depending on the case, supported with evidence. And that new evidence could be evidence that the police have grossly failed and it's been missed, or evidence of new witnesses, people that have given other accounts, that are prepared to say, well, actually, that isn't true. You know, they're prepared to come to court and say, that didn't happen as it did. And finally, I do want to touch on the CCRC. I will have my little bit of a gripe because, and there are 3 cases specifically that I'll give as an example. First one, it's a gentleman in Northern Ireland, historical sexual offences. He was sentenced to 20 years as an IPP prisoner, which is another whole beef. 20 years as an IPP prisoner. He was actually released after just 10 years back in November 21, and we're still fighting his case. So the CCRC, I found in a subject access request that was probably the best part of 2.5 inches thick, right at the bottom, an 11 emails. Pardon? No, it was actually 11 emails, so it's the chronology, 11 emails. And it was discovered that the police and the public prosecution in Northern Ireland knew that he hadn't been in the location. They got that about 2 weeks before his trial. What did they do with it? Shelve it. Now, I put that into the CCRC as part of, I helped this guy, because the guys ran out of money. And I helped him and said, right, we'll do your application. And we submitted this to the CCRC. The CCRC came back and said, I know, but it doesn't prove he hadn't nipped home for the weekend. And it was like, okay, so if that was the case, why was the evidence never disclosed? Why was that evidence held by the police and by the Public Prosecution Service in Northern Ireland? That is just one case, and it's a case we're hoping to put in another appeal. The second one was this gentleman who is alleged to have tried to murder his new bride, the case I mentioned earlier. They'd gone on honeymoon to Dubai. She alleges that he tried to drown her in the bath. Okay? He said from day one, there wasn't a bath in the hotel room. And he got a photograph from the hotel to show there was no bath in the room he stayed. This was put to her at trial, and she said, actually, the first room that we were put in, we were moved out of to a room that did have a bathroom. We were moved out at 5 o'clock in the morning after we'd arrived the night before, and the staff asked us to move. And this was accepted. This was accepted by the jury. Okay? The father of my client went to Dubai, spoke to the hotel, took the hotel manager to the police station, who gave a full statement, who said, no, she stayed in that room from the moment she arrived till there. Now, this was post-conviction. So this, for me, I'm rubbing my hands on this is it. This is brand new, fresh evidence. Okay? I contacted the CCRC, and basically what they've said is, this issue was dealt with at trial, and therefore we're not going to take any further action on this. I challenged him and said, look, why don't you just contact Dubai Police, send them an email, they'll send you a copy of the statement. No, this case is now closed, and that was it. So it's not closed because we're now looking to try and get a copy of that. That'll be our next thing. And the way we'll word it to the CCRC is, this evidence is sitting there. Please contact this police officer who took this evidence. I've got a Section 9 statement from the father who went out to Dubai. This evidence is sitting there in this Dubai police station. It was taken by this officer in this room number on this date at this time. Please, can you obtain a copy of that statement? And that is sadly, it's probably going to be our last attempt with this guy. And finally is the Robin Garbutt case. And I have to mention this on behalf of Jane and Mike. Robin Garbutt was convicted 20 years for murdering his wife, Diana Garbutt. We obtained, Jane and I actually went to the scene. This is years after I initially worked on the Robin Garbutt case. We went to the scene of the murder. We worked out from police photographs exactly where the murder weapon was found. It was found, the murder weapon was sort of about that big, and it was found on top of a wall opposite the post office, and it was hanging out by about that much. We've got the police photographs, and we've been able to work out exactly where on the wall that was taken from the police photographs. We've also got a screenshot that was taken it was Time TV footage that was taken on the day of the murder or the day after the murder. Unfortunately, there's no date timestamp on this. And you've got a photograph of two plainclothes officers walking down the road directly below where the murder weapon would have been in situ. There is no, you can zoom in all you like, there is no murder weapon, and you would have seen the murder weapon. So the murder weapon wasn't there, but it was found 3 days after the murder. So somebody has placed the murder weapon to be found on the wall. By that time, Robin Garbutt had been, correct me if I'm wrong, Jane, Robin Garbutt had been removed from the property and he never went back to the property. So there's no way he could have placed it there, but somebody placed the murder weapon there. The murder weapon matches exactly the murder of Diana Garbutt, right down to the rust stains on the pillow where she was murdered. So that's me more or less done. I'm probably gone over by probably about 10 minutes or so.
I think what Mike kind of raises, I think a really important issue is about trust, and it's about the way that